This week, the Supreme Court will take up a challenge to the Voting Rights Act, and the result could have a massive impact on U.S. elections. At the heart of the case is Section 5 of the Voting Rights Act, which requires certain towns, counties, and states to get pre-clearance from the Justice Department or a federal court before making changes to voting procedures in districts, among other things. Here to break it down for us, former Deputy Assistant Attorney General Thomas Dupree and Chief Counsel for the Constitutional Accountability Center, Elizabeth Wydra. Great to see you both.
Great to see you, Shannon.
Thanks, Shannon.
All right, Elizabeth, what's at stake in this case?
Well, the Voting Rights Act is one of the most iconic laws that has passed in the past century, and it guarantees, it makes a reality the 15th Amendment's guarantee of the right to vote free from racial discrimination. The 15th Amendment, as most people know, and probably even more after watching Lincoln, the movie, the 15th Amendment was passed after the Civil War, but the right to vote free from discrimination wasn't made a reality for most minorities and African Americans, particularly in the South, until the Voting Rights Act of 1965 was passed. And just as important as it was then, it continues to be the best defense against voting discrimination that we have today.
Well, and Tom, the Shelby County authorities out of Alabama say, listen, a lot has changed since 1965 when this was passed. You know, the political realities of today are that Section 5 shouldn't be a burden on those of us who've gotten our act together, essentially.
That's exactly right. The United States of today is very different from the way the country was in the 1960s, and the same holds true with Alabama. And what's at issue here is not the Voting Rights Act as a whole, because I agree with Elizabeth that the statute has played a key role in our nation's history. But one particular aspect of the statute is what's going to be before the Supreme Court, the pre-clearance requirement, which basically requires states like Alabama and other states to go to the Justice Department or the federal government and say, we'd like to make a change in our voting laws. And they have to get approval from the federal government before they can do that.
And we've seen this play out a lot, even over the last couple of years, things about voter ID or changing redistricting. I mean, Texas had this major overhaul of redistricting, and that involved the Voting Rights Act. Now, a couple of years ago, I guess it was 2009, there was another case involving the Voting Rights Act that didn't specifically get to whether or not Section 5 was still going to be any good, but there were hints from the Chief Justice that it may be time to revisit that. Who are you going to be looking at, Elizabeth, and who do you think are the key players here?
Well, obviously, you want to look at Justice Anthony Kennedy, who has traditionally been the swing vote. But, you know, I think it's important to note that while, yes, things have changed, there has been some progress. You know, for those states that can show, hey, you know, we're totally different, we have, you know, reformed our ways, they can bail out under a provision of the Voting Rights Act and get out from under the burdens. But it's telling that Shelby County, Alabama, the one bringing the Supreme Court case, can't take advantage of that because they can't show that they have been free of discriminatory voting practices for the past 10 years. So in Shelby County and in many other covered jurisdictions, the Voting Rights Act remains incredibly important and the best way for most American voters, for all American voters, to be sure that their vote will count equally at the ballot.
Well, and Congress has to renew provisions of the Voting Rights Act. They most recently did that in 2006 with strong bipartisan support in both houses. So we know that Congress has a role. I mean, it's a potential that it would expire without Congress and the courts getting involved. Shelby County, among others, argues that it's expensive, it's time-consuming for them to come and try to get these pre-clearance objectives met. But Congress has passed this again, Tom, so, you know, where do we go with that?
Well, Congress has passed it, but let's not forget the ultimate voters here are the justices of the United States Supreme Court. They're the ones who are going to decide whether or not this is constitutional. And I think, as you alluded to a minute ago, Shannon, the Supreme Court a few years ago looked at this, and all 9 justices said that this may have gone too far. And when you have a hotly contested constitutional issue that unites justices as diverse as Justice Scalia and Justice Sotomayor, that's telling you something.
You're saying something. All right, this case will be argued this week on Wednesday, and then we'll stand by with a decision by June.
Absolutely.
Thank you both.
Great. Thanks,
Shannon.